They call it a warrant. You have the warrant to sit on a particular case. It's the same thing. And if you go to the AG department, you see prosecutors on specific cases. You get it? It means that internally there's a certain directive or instruction by the head of the firm that says, you handle this case, you handle that case, you handle that case. And you may see somebody else coming in under different circumstances. Maybe the person handling the case is not around at that material moment. Or maybe there's a complication along the line that requires a more experienced hand on the particular case. Then you find another person taking over or intervening. So that is not an unknown practice to lawyers and to the law. In a similar fashion, if we are insisting on, even though I hold a different opinion, I don't think that, like I gave you the background yesterday, the framers of the law intended for a truly autonomous and independent institution of a special prosecutor. That has always been the intendment of we the people from the very beginning. And fashioning that out, there was that obvious constitutional problem that we all danced around. And the lawyers had always argued it, even before the law was passed. It went into Parliament. That same argument came up in Parliament. And so if you recall, all those who were initially against it, the likes of the now majority leader, all of them had that posturing that there's a certain conflict that this law is going to create. But we failed to deal with the problem at the lawmaker level, at the parliamentary level, which is where we could have initiated that constitutional amendment that would deal with this, so that we don't, to remedy the mischief that we see today. But that is spilled milk. We can't continue crying over it. What do we do now? Two options. The long way to go is to ensure that the constitutional amendments that are ongoing, the committee is done with its work. Inputs were made. And ironically, I'm not sure we heard anything from the reports that HKP shared with the president, the excerpts that were shared.
Professor Kwesi Prempeh.
Yes. I'm not sure we heard any excerpts. I'm not sure we heard anything about institutionalizing the OASP with a constitutional mention. I'm not sure there was anything to that effect. But I'm also not sure that it is too late for us to be able to do this, because it is the only way we can deal with problems like this. The short way is, if you need authorization, you need to give a certain review and advice on a docket before the OASP goes ahead to prosecute. Don't just issue that, and all this will go away. I don't think that we are oversimplifying the issues when we argue like this. I don't think so.
I don't want to cut you, but on that score, if we argue that it's a matter of a simple fiat, and I heard, the Honorable Tampuli made that point to me as well. It leads me to ask the question. The bill was passed in 2017. It was assented to in 2018. Between that time up until now, was there a fiat from either Gloria Kufu when she was then Attorney General to Godfred Dame when he was Attorney General? Was there ever a fiat? Was there a need for a fiat? Were there conversations about a fiat?
I honestly don't know.
And then now, I want to.
What is changing?
And what is changing? It's one of them. Is one of the many questions. Was there a fiat?
I'm not sure. I'm not
which
sure
is
there
which
was.
is which is a question I'm asking.
I'm not sure there was ever a case that the Attorney General had to okay a docket before the OSP went ahead to prosecute. I'm not sure about that. I, as a court reporter, when Godfrey Dame was AG, he's one AG that personally I got to have a lot of interactions with, often after court. We would chat about a lot of things. We'll get to ask him some of the questions he won't answer on the record, so that at least you get to understand why the AG is doing certain things that it is doing. As a journalist, these are things that benefits that we got, reporting on certain cases. And this never came up. In fact, none of us ever asked. And that information was never volunteered. Maybe because that conflict was not apparent. It's been apparent. Maybe because it had not been ignited. That is the word I'm looking for. Maybe that is why it never clicks for us to have that conversation. But I personally am not aware of any instance at which the AG then, whether Gloria Akufu or Godfrey Dame, had to, authorize expressly delegating prosecutorial powers to the OSP. I'm not aware of any of such precedent. You see, even if that is the case, I made this argument to off-air yesterday in a conversation that, look, the way the members of the government are handling this case, it may turn out badly for the administration. Because if you don't tackle this properly, then it will be viewed as government interfering with the fight against corruption, or government dismantling the machinery on the fight against corruption. And that's not the kind of perception President Mahama wants on himself or his administration. I don't think so. So it has to be properly handled. First, it came from, it started with heated parliamentary debate, people taking on the SP personally and the OSP generally, demanding his removal, demanding dissolution of the office, went on to a near initiation of a private member bill to, dismantle the office of the special prosecutor, had to take the intervention of the president for that bill not to be initiated. Then we went on to listen to commentary from leading members of parliament on the NDC side, the majority side, which I have always said were in bad taste. And I say this because I keep going back to the entire foundation for the establishment of the office of the special prosecutor. Where I disagree completely with the Honorable Hassan Tampuli and members of his caucus would be that direct push or attack on the president. This was a suit initiated by a private citizen. This was a decision of a court of competent jurisdiction, properly constituted, with the matters brought before the court, and the court looked into it and pronounced judgment. This was not a case that was initiated by any member of the administration. This was not a case, as far as we know, instigated by any member of the government, as far as we know. And once a court makes a pronouncement, every lawyer knows. And the Honorable Tampuli is a lawyer. Once a court makes a pronouncement, makes a judgment, it becomes law until otherwise displaced. So you cannot blame the Attorney General for saying that, yes, we are taking over the cases in accordance with the orders of the court.
But the haste with which
What is the
being
haste?
done.
There are cases being prosecuted. People are on remand. You cannot remand somebody beyond a certain period. You cannot keep people because there's an institutional fight. It shouldn't affect the prosecutions that are happening. So if an order was made yesterday for the Attorney General to take over the cases, it is only proper that the Attorney General immediately takes over the cases in the interest and for the benefit of the people who are being prosecuted. Again, unless we are expecting the president to directly interfere with an order of the court, then we cannot be asking the president to, as he did with the private member bill, to intervene in this. How will the president even intervene?
6.
To say that the order should not be followed. We expect the president...
Authorization is all that is all that the OSP needs. A fiat, a simple fiat written. And you see,
a fiat is not simple.
in this context, in the context of the conversation,
we can start calling you lawyer. Be careful.
I beg you. You can't start calling me lawyer. I beg you. I am not a lawyer.
A fiat is not simple.
No, I said in the context of the conversation, right? And I say this because
yes,
yesterday,
in the context, more so in the context of the what you call it,
in the context
the
of
conversation,
right?
There are before the AG will issue such a fiat, he would have to review the dockets.
All dockets.
Yes. AG will not just come and say that the law says that.
Fair enough.
So the order has put us in a more complicated situation than we want to believe.
So let me come in on that bit as to how the president can intervene. The president's intervention, if his position when the private members' bill was being mooted was that this is an office that must continue to stay. Ghanaians should be patient with it. It will deliver on the promise, and he is not for the abolishment of the office.
And I don't think his position has changed.
His position has not changed. But his position will be undermined if
the order is followed.
If the Attorney General, instead of working with the special prosecutor, and I use working advisedly because that will be the authorization, and to allow the office of the special prosecutor do what it is expected to do, the AG rather says, oh, we are going to take over the cases. Wouldn't that be undermining the president's request? Because the president said, I believe the OSP must stay and do its work.
Yes.
If all it takes is the fiat, why are you not giving it the fiat, the authorization to proceed to do the work?
Let me try to distinguish the two situations. The private member bill was championed by the majority leader and his chief whip. Was it a chief whip? Was it?
Yes.
Dafia Mako, the Honorable Dafia Mako. They were the key promoters of that private member bill. They are members of the executive, advisedly used. The majority leader is leader of government business in parliament. The majority leader sits in cabinet.
So does the Attorney General.
So does the Attorney General. So it is easier for Mr. President at a cabinet meeting to instruct the leader of his business in the house. Tell him, this thing that you are doing in the house is hurting my principled stance on this matter. Withdraw immediately. And that would be a direct instruction to the leader of his business.
That feeds directly into what the minority is saying.
Exactly. And that is where my problem is. In this case, an independent arm of government, independent in all the sense of, in all of its senses,
The Attorney General's office?
the court,
Okay.
has made an order. The order says, Attorney General, take over all the cases immediately.
Or give authorization. That's what the court said. The court didn't say that. The court told the OSP that go and get authorization and come and prosecute. Or the AG takes over the cases. Why not the other one, which says give authorization? But they are in a hurry to go and take over the cases. That's a question that, because
I don't know.
that was the per the report which we got from the court. That was it wasn't just a one order. It was an option.
I started by saying that, especially when you use the expression simple fiat. I said that no, relax.
It is in a context.
Relax for me. I'm not disagreeing with your context. I started by saying that authorization would not just be issued blindly. Is that the intendment of the law, the act? Is the act saying that, yes, the act does not tell us in what form or manner that power is delegated. The act says that the OSP prosecutes on the authority of the Attorney General. In what form and manner is that authority exercised by the Attorney General and manifested on the OSP? In what form? The law does not say that.
No, there is another legislation. I don't know what LI, whether it's an LI or an act, but under the previous administration, there was an enactment of some sort which allowed the Attorney General delegates powers. And perhaps to all of my lawyer friends who are listening, please help me with that specific regulation. It was based on that it's LI that the fiat, for instance, to the NPA was issued. And so if you read portions of it, it didn't even make reference to the constitutional provisions in 83, 84 to say I've delegated the powers. It just made reference specific to the act. I will try and get that.
Well, you are still not following the point I'm making.
Okay.
I'm not disagreeing with you.
No,
I am saying
I am
I'm
actually
saying that
trying to
if
corroborate.
there's supposed to
wait,
be,
I'm only trying to corroborate the point you are making. That because the act, the OSP Act, did not clarify the manner and form in which that authorization should come. I am saying that another law was passed, which sort of gives an idea as to how the AG can delegate prosecutorial powers to other agencies. Can we say we will make reference to that as guidance in this case for the OSP? Is a point I'm making, so that we can look at that legislation instead of zeroing in on the point you are making. Is all I'm saying.
Okay. And still building on that. Will that authorization be for specific cases, or that authorization would be a blanket authorization to the office of the special prosecutor to say that henceforth you have my permission to prosecute all cases that you take on, all cases that you investigate? You have the authority to prosecute them without having to revert to me every time you would have to prosecute. Yesterday, we used the example of the police prosecutors, as we call them. Every single docket handled at the lower courts, where usually you would find the police prosecutors, would always go to the Attorney General for advice before it comes back. It goes to the Attorney General's department. The advice is given. It comes back to the the department prosecuting, then they take the matter up and they go ahead with the prosecution or do as has been advised by the Attorney General. Every single docket. Can that argument be stretched to say that SP is prosecuting Mustafa Hamid, or formerly of NPA? SP presents the docket in the case of Mustafa Hamid to Attorney General for advice. Attorney General advises, yes, you may go ahead to prosecute this matter. Then SP wants to prosecute Abdul Hanan, formerly of Buffer Stock. Then SP again presents that docket to the Attorney General. That's the one way. Or we are saying that Attorney General will issue a blanket, what we call blank check in general language, on the authority of the Constitution and on the authority of the Constitution, I hereby give you authorization or authority to prosecute cases that come within the ambit of the OSP Act. Is that what we are saying? So it's not as simple as ABC issuing that fiat, which is why I am saying that we cannot also entirely blame the Attorney General for picking up the cases in accordance with the order of the court. Yesterday again I mentioned that there are two things open to the OSP. You can take this up by way of appeal, which is a long way to go. Or you can simply go straight to the the Supreme Court, where you would question the jurisdiction of the High Court in making that particular order. In which case, the Supreme Court would simply either quash the order or uphold it. So, I mean, the OSP still has a lot to do in this matter that will resolve it. With all the options that I talk about, all the options that are available to us in this matter, the OSP remains the key figure in dealing with or bringing the solution to this matter. What we should not do is to begin to make comments as the president, if he believes in the fight against corruption, should intervene. I really don't see how the president would intervene in this matter. It will still drag. Yes, unless there's evidence to suggest that the Attorney General is not interested in giving that authorization because the Attorney General wants to hijack the office of the Special Prosecutor, take over its cases. Unless there's an argument, in which case I would have to go and look for evidence to come and argue that one. But as it stands now, we cannot blame the president. You cannot say, Mr. President, intervene. Intervene in what? How should the president intervene in this matter? The first one was clear, within the executive. This one, if he crosses to intervene, I will say on this same platform that he's interfering with the independence of the judiciary. Because once a court makes an order, in any case, the court is now the court has no authority in this matter again. The judgment has been pronounced. Once judgment is pronounced, the court loses all of its. You don't have, the matter is out of your hands now. Any other thing that must happen going forward would and should be initiated by the SP and his team. So let us play down the partisan politics a notch and see how, luckily for us, we know the president has expressly communicated his commitment to the office of the Special Prosecutor. So I think the minority should feed into that. hold the president to that. That even if it has to take an audience with the president, the minority can seek audience with the president.
Right. I will come back to the High Court ruling because that was the basis upon which, or that is the basis upon which we are having this conversation. And I pivot back to what the orders were. Go for authorization, or the cases will have to be transferred to the Attorney General. I am making the point that we cannot look at that order as illegal as it has been suggested by a lot of as illegal as it has been suggested by a lot of lawyers who tell us that until it is overturned, it is something that must be respected.
Did you say illegal?
I say illegal in the sense that that's why I said illegal in the sense of what lawyers have been saying, that the court did not have jurisdiction. It should not have made the pronouncement it made in the first place. And so I use illegal advisedly in that context. In that context, for want of a better word. It still is something that must be, or a wrong judgment. So let me not say illegal, a wrong judgment based upon all of the, assertions, the interviews, the many people we've been speaking to, and the many people who've been sharing their thoughts. It will continue to remain in force until it is overturned.
Yes.
There were two options. Give the authorization. And this one, I'm hearing a number of persons as well asking that we explain what the fiat is. The fiat is simply the Attorney General in writing granting authorization to the special prosecutor to prosecute matters of corruption and corruption-related offenses, which is captured in their mandate or their objectives in the law which created them. The Attorney General will write and say, I give you authorization to prosecute those matters in my name. Because if you look at the Constitution, which is one of the many things we've been having a conversation about since this came up, it says that only the Attorney General can prosecute all criminal matters, whether corruption, stealing, whatever. Once it is a crime, only the Attorney General can initiate and continue with prosecution on that score. But the Attorney General cannot be everywhere, cannot do everything at every time. In the wisdom of the people who sat down.
I'm sure the department is spread thin.
Exactly. In the wisdom of the people who sat down and put the Constitution together, said that because there may be challenges with being everywhere, you can delegate your powers. You can give some of your powers to prosecute to somebody else to do it on your behalf. And so the fiat we are talking about is just the Attorney General writing to tell the OSP that I have delegated some of the powers to you, and so proceed. Right? There were two orders. One of such which was, there was an option, not two orders. There was an option. One of such which is that go to the Attorney General and get the authorization. And I am asking the question, why is the Attorney General
I'm trying to see whether that second option
only saying that we are going to take over the cases and not also mentioning we have attempted to give authorization and they say no, we are independent already and so we don't need the authorization. That's the point I'm making. And back to the authorization, because you asked a number of questions in relation to it, that it is not as simple as it's supposed, as I make it seem. I would disagree with you on that score, that it could be simple because it is an authorization. It could be. But in your analysis, you made a point as to in what form it should come in and whether or not it will require the Attorney General to have briefings of some sort or an overview as to the cases, I believe that will go or will touch directly to the independence of the SP. If the Attorney General will have to be looking over and be saying that, okay, on this case, I think you should go in this direction because you're using my powers to prosecute.
Let me read the notes.
You do that. I just want to conclude the point. Which brings us back to the law which was passed, where it has been stated quite clearly that it was problematic from the start and it should have cured this challenge to avoid all of this debate this morning. But proceed on the note.
Okay. This is notes I'm picking from our court reporters platform. And this is somebody who was in court, a reporter who was in court and put the notes on the platform. So let me read this. Court orders AG to take over all prosecutions in various courts which are being handled by OSP pending the outcome of authorization from AG. Listen. Pending the outcome of authorization from AG.
So, no, go back. Start it again.
Court orders AG to take over all prosecutions in various courts which are being handled by OSP pending the outcome of authorization from AG. The court has declared as void all prosecutions pending, application granted, and all reliefs granted, cost of 15,000 awarded against respondent. And the respondent here would be the OSP. Okay. Let me go back to that line. Pending the outcome of authorization. That is why I said that authorization would not just be, okay, Mawina, you are prosecuting what? Mustafa Hamid. You are prosecuting Abdul Hanan. You are prosecuting Gifty Owari. Gifty Owari is under the AG, right?
Yes, under the AG.
Which are the other cases there? You are prosecuting Ken Oforiatta and all those other cases. Okay. Go and continue prosecuting all of them. That's the one form. Or you are prosecuting Ken Oforiatta. Let me see what you have on your file. Then they bring the file. They go through the file. Then there are conferences over the file. Why don't you have this? Why do you have this? Why did you not plug this loophole? Why you will not get a conviction from here? You will not. It's like me standing before my senior, with my senior, asking my senior to look at my file for me. That is the other form, and which will take time. It is not an overnight matter. So they will pick Ken Oforiatta, the file, pick Abdul Hanan's file, pick Mustafa Hamid's file, and then they will look at them individually. When the department is satisfied that this is a winnable case, it is prosecutable, then they give the authorization to go ahead and prosecute. So that is the other way. So the point is, following or relying on the notes that I have just read out here, it didn't say that take over or give. It says take over pending, because the court itself acknowledges that the authorization process is not a simple process. Even though the court, I don't know what the court would have relied on to come to that conclusion, that process is not a simple process. That is why yesterday also I mentioned that we would have to be able to read the judgment, so we know why the judge ordered what he ordered. You get it? So I again, OSP, this is at your doorstep. Quickly, immediately, run to the Supreme Court and deal with this matter. Let's stop expecting things from the the presidency. Yes, the president can make public pronouncements, can say that, well, I believe the court erred. Why would the president say he believed the court erred? You get it. So, I mean, yes, the president is also a citizen. He can express his opinion on judgments and all of that, but he is the president. If he comes in public to say that I believe the court erred or I believe the court was right, it would give us an insight into a certain thinking of the executive and how the executive is either planning to influence or not to influence, which is the reason why if I were advising the president, I would tell the president, don't comment on this matter. Don't do anything on this matter. The order, as per the notes I have seen, is clear. Pending the authorization.
I think my question still holds about the authorization. We didn't hear a single word about the authorization in the post by the deputy AG.
Oh, okay. I can't speak for him on that. I don't know why he would have.
So
I just read the notes.
I know.
You have reported from the court. So when you sit in court, you are typing exactly what the judge is saying.
Yes.
So I mean, I won't be able to say why Deputy AG will go and put up a post and mention one bit and not mention the other bit. But based on the notes, which are very reliable, that I have read here, I believe that the AG did nothing wrong by saying that we are taking over the cases immediately.
But the second leg.
No.
About authorization, which is where which is what brings about the question as to
Mawina. For me, that is not even a problem.
No,
I'm saying that will not even resolve anything.
The authorization.
This whether the authorization is coming on, it is not what will resolve the matter. What will resolve the matter is a higher pronouncement, a pronouncement from a higher court on the order. That is the way I want to see. If the Supreme Court comes to uphold this order, I mean, then we all go back to the drawing board, because there would have been a final decision on it. We all go back to the drawing board and see how we deal with it. Again, I have mentioned time without number. The other way that we can deal with it, put this in the Constitution. And I am making this argument because I believe
the OSP has made similar arguments to Cecil.
I believe that office is needed. I believe that office is relevant. So let's not hide behind constitutional loopholes to scrap an office that we so desperately need. We've made the argument in the past before. Decouple the Ministry of Justice from the Attorney General. If you don't want to do that, take the Director of Public Prosecutions. Take the Director of Public Prosecutions, make that an office, and give powers of the OSP to the Director of Public Prosecutions, DPP. That is another argument that has been made. In fact, there are a lot of options that we have considered in the past before eventually coming to this act establishing the office. And so, I mean, we don't have to go back and re-argue all that have been argued already.
All right.
Let's look at how we deal with this in a manner that does not hurt the fight against corruption. That's all I'm saying. But the politicization is a no. So I agree with the Honorable Hassan Tampuli on some of the things. On the other things, I disagree with him. And I think that...
when he says this falls squarely at the feet of the president.
Yes, I disagree with him.
Right.
I don't want to see my president interfering with my judiciary. So president will call...
No, I don't think the interference, and this is because I spoke to him, right? Mm-hmm. I don't think the interference bit is with the judiciary. And so he laid a premise and said, look, there was the private member's motion, which failed. He argues that there have been more than 10 petitions which have been taken to the presidency seeking to remove the special prosecutor, the current special prosecutor, which could not pass the test of prima facie. Now,
which is also not within the
fair
domain
enough.
of the
I'm
president.
just waiting for the argument to me, because Oreku is here. He will do sports for us, and so I have to do that quickly. And he argues that a private individual, yes, in his independent capacity, who has worked in the past with the Deputy Attorney General, is in the Supreme Court seeking to question the authority of the special prosecutor. He argues that it may be in his personal capacity, but within the public bird's eye view, that is too close a relationship for you to just say it is casual. And so it is looking like there has been, or there is, a plan, a scheme of some sort to remove him. That is why, if the president believes in his assertion, when I think some CSOs, was it the clergy, went to him about, and he made the comment, then he should be speaking to the Attorney General that give the guy the authorization so that he will do the work. If you are not doing that, which is a part of what you read,
the argument,
then you are making it come off as you want him gone, and you've used A, you've used B, you've used that, and that is the case. I'm not saying that's my argument. I'm just
I get it. You
you
laid a premise that he laid, the Honorable Tampuli laid.
Yes.
And my point is that the premise upon which he made the argument in itself, the premise in itself is flawed. Which is why I took the pains to explain that the private member bill was directly within the powers and authority of the president. So the president could directly influence that. I mean, if you admit that there have been several petitions sent to the presidency seeking the removal of the special prosecutor,
that's not within the president's
which is not also within the president's remit. But you say that one too didn't see the light of day, as if to suggest that the president did something to influence that as well. Then that should tell you that, I mean, for the president as president, his personal belief or conviction on this matter influences his decision where he could control it.
Right. Let's go for this quick break. When we return, we'll have sport for us, and so I have to do that quickly. And he argues that a private individual, yes, in his independent capacity, who has worked in the past with the Deputy Attorney General, is in the Supreme Court seeking to question the authority of the special prosecutor. He argues that it may be in his personal capacity, but within the public bird's eye view, that is too close a relationship for you to just say it is casual. And so it is looking like there has been, or there is, a plan, a scheme of some sort to remove him. That is why, if the president believes in his assertion, when I think some CSOs, was it the clergy, went to him about, and he made the comment, then he should be speaking to the Attorney General that give the guy the authorization so that he will do the work. If you are not doing that, which is a part of what you read,
the argument,
then you are making it come off as you want him gone, and you've used A, you've used B, you've used that, and that is the case. I'm not saying that's my argument. I'm just
I get it. You laid a premise that he laid, the Honorable Tampuli laid.
Yes.
And my point is that the premise upon which he made the argument in itself, the premise in itself is flawed. Which is why I took the pains to explain that the private member bill was directly within the powers and authority of the president. So the president could directly influence that. I mean, if you admit that there have been several petitions sent to the presidency seeking the removal of the special prosecutor,
that's not within the president's
which is not also within the president's remit. But you say that one too didn't see the light of day, as if to suggest that the president did something to influence that as well. Then that should tell you that, I mean, for the president as president, his personal belief or conviction on this matter influences his decision where he could control it.
Right. Let's go for this quick break. When we return, we'll have sports, and then the big conversation will come up. and we'll let a few of you as well share your thoughts in terms of the messages. But a good morning to Law Lecturer John Baptist Aja, who's been sharing quite the opinion as well in relation to this. He's disagreed with you on the fiat and said it is not as difficult as it seems, and so the AG should be working towards granting that.
No, but I asked 2 questions.
Yeah, which is fair. I'm just reading that point.
So based on the 2 questions, I said no, it cannot be as simple a process as it appears to be. But of course, he is my senior by far. I defer to his superior knowledge.
That's